Good afternoon, everybody, and welcome to our spring conference. Happy March to everybody. Hope you're having a good spring semester so far, and that 2022 is going well. Just when we got over we're starting to get over the pandemic, the Russians decided to make things interesting in the last couple weeks. So we'll see where we go from there. I'm sure the kids looking at their history book or whatever they're going to be looking at in 50 years will look back at these last couple of years and kind of cringe as to what's going on. But we shall carry on. But what I'm going to talk about today is with respect to the topic of our conference with autism. I'm going to give us a summary of what's been going on in the courts, primarily from the last year, 2021 up to the present, and not always deal with autism, but some just deal with some of the more major cases that we've had over the last year. So let's go to the PowerPoint, which is available on everybody's screen here, and we'll move forward on that. As I said, you know, the special ed litigation compared to last year in 2021, first of all, the number of cases have increased. I remember when I went through this topic last year, we didn't have quite as many, obviously, because of the COVID pandemic. So we didn't have a lot of due process hearings. The courts were really stalled out, so we didn't have quite as many decisions. But I noticed with, particularly in Texas and the special education decisions in 2021, the numbers increased. And that could be just you know, there was challenge. A lot of these things now, we have challenges to the remote learning that are coming into play. So there are more complaints and more cases filed in that regard. And also, I think just over time, we learned how to adapt in terms of how to do a hearing. Now, that wasn't necessarily true on the federal and state court side. Those cases are still pretty backlogged, and when you're dealing with civil cases, whether it's a federal case or a state case, the criminal cases have precedence. So when those cases got backed up, now that we're starting to get some jury trials, the criminal cases got precedence in terms of moving forward. So, and whether these things have been done in person or not, it really depends on the jurisdiction. So the federal courts are pretty uniform in what they've done, but the state courts, there's some uniformity there, but a lot of it depends on counties in terms of how the numbers are in any given county at any given time. So as we said here at the beginning of March, Omicron has moved down quite a bit, and just knock on wood, hopefully we don't have any other variants to mess with things, and we can get back to normal relatively soon here. So from the special education side, you know, a lot of the administrative hearings that we've had, and this is really true across the board, but with our special education hearings, most of those have been held remotely, and a lot of them continue to be held remotely. Like I said, we've learned to adapt to that to a certain extent, and the decisions are being made. Now, it does present some challenges when you're doing a hearing remotely, and if any of you have gone through that process, you can see what it's like, or you've experienced what it's like. You know, everybody's sitting behind their computer, and which is an odd way to go about doing a trial or a trial-like experience. So some of the problems that we've had have been like submitting documents. Of course, we have to do our disclosures when you're dealing with due process hearings, and that can be troublesome when you're trying to get those documents into everybody's hands, particularly if it is a fairly complicated case and you have a lot of documents. So you try to get it on the screen, and then everybody's supposed to look at it. That's a lot easier when you just have notebooks or you have computers and everybody is in the same area. So that has been a bit of a challenge. The examination of witnesses has been somewhat of a challenge too. I think witnesses, from our experience, have been a little more comfortable because they can either be at home, they can be in an office, they don't have people around, they don't have anybody in their face. So it's probably, excuse me, a little more of a relaxing environment as far as the witnesses are concerned. But when you're trying to do a cross-examination or when you're watching a direct examination, you can't see the body language and the fidgeting and all those types of things. That is important for a judge to see when you're going through this process. Or if you're in a court setting, if there's a jury involved, to see, read the body language of the witnesses. But regardless, the Zoom hearings have continued on. A lot of folks want to continue with that, so we'll see. It's going to be up to the hearing officer to make those determinations moving forward. But again, as the Omicron wave tends to dissipate a little more, I expect to see a little more in-person situations. One thing that has continued and really for the most part has been fairly successful has been virtual mediations. I think in that case where it's not as dependent on seeing how people react and seeing the body language, and you don't have as much documentation involved, that seems to be more efficient, and it's a lot of those mediations have been successful. And if they're not successful, they're efficient in terms of they end quickly. So if we're not going to get to a resolution, you don't have everybody in one place and traveling and all that, where you can break apart a little easier. The mediations are good because there's less confrontation involved. And of course, the mediation process by itself, of course, is usually the parties in separate rooms and the mediator going back and forth and trying to negotiate a settlement. So there's not a lot of confrontation, but there can be some stress if the parents have to come to like the school administration building. They see each other. Sometimes if it's a situation where it has gotten to be some personality conflicts, that can be a little difficult. So the beauty of the Zoom mediations or the virtual mediations is that it eliminates that factor. And of course, they're less costly because you don't have people traveling all over the place. And the other thing is, and if you've ever been in a mediation, they can take all day, and sometimes late into the night, and sometimes into additional days. So with what happens when the mediator is with one side during the mediation process, it might take a couple of hours to go over the facts, put together a settlement proposal, and come back. So in the meantime, the other folks are on the other side with really nothing to do at that point. When the virtual mediations allow the parties to kind of go about their day and their business and still come back and be focused in on the mediation. So again, those have been pretty successful. We've learned to live with the Zoom situations, and we've also moved forward with more in-person kinds of things. Going back to the Zoom and the virtual hearings, even the U.S. Supreme Court, which we'll talk about in a minute, has just recently gone back to in-person oral argument. They were done by phone for a fairly long time, and some of the justices are still appearing by telephone. I heard something recently, was an interview with Justice Sotomayor, and she's got some, she's immunocompromised in some ways, so she hadn't returned back to the Supreme Court for oral argument. She's still hearing things through telephone. So we'll see how that goes moving forward. But again, we're trying as much as possible to get back to normal if we can. So as I go through these, I'm going to go through some cases in a little bit. I'm going to talk about a couple of other issues first. Primarily when I do a case review of what's been going on in the last year, I like to look when you're dealing with IDEA or you're dealing with 504s, look at the Supreme Court. I like to look at the Fifth Circuit, which is our federal court of appeals, which is the level below the U.S. Supreme Court. But that's one that covers Texas, Louisiana, and a couple of other states. But that is I primarily look at those decisions because they provide precedent to us here in Texas. And of course, we also have the Texas hearing officer decisions. Generally don't talk about cases that are hearing officer decisions from other states because they don't really have relevance to us because they don't serve any type of precedential value. So they don't serve as precedent. And they, their systems are many times different than what we have in Texas. So they might have a two-pronged system. It might not be as formalistic as far as the hearing is concerned. So it doesn't really help to look at a decision on autism from a hearing officer in South Dakota, because it's not going to really have any relevance to us here in Texas. So you'll see when I look at cases, I focus on the Supreme Court, the Fifth Circuit, of course, any district courts within the Fifth Circuit, because those cases are appealed up to the Fifth Circuit, and then our Texas hearing officer decisions. So before we move forward on cases, let's talk a little bit about the current legal standard in IDEA cases. Now, you've all heard of the Andrew F. versus Douglas County case at this point, and this is the one that addressed the standard that we look at with respect to IDEA cases and whether the school district is providing a FAPE. The reason I bring this up is because, as you know, it takes a minute for cases to matriculate up to the courts. This case came out several years ago. It articulated a new standard, but now we're starting to see the cases, whether it's the hearing officer cases or the court cases particularly, you're starting to see the application of this Andrew F. standard as opposed to the Raleigh standard in cases. So we'll keep that in mind as we go through the cases. Now remember, what this is the current standard, and this is a quote right out of the Andrew F. case, that if grade level advancement is not a reasonable prospect for the child, his IEP need not aim for it, but his educational program must be appropriately ambitious in light of his circumstances. Again, that's obviously a very fact-specific case-by-case basis, but that's the standard. Is it appropriately ambitious in light of his circumstances? Just as advancement from grade to grade is appropriately ambitious for most children in the regular classroom. Okay, again, the Supreme Court in that decision, we're looking at the standard to apply to today's cases. The Supreme Court explicitly held that school does not have to provide a child with a disability opportunities to achieve academic success, attain self-sufficiency, and contribute to society that are substantially equal to the opportunities afforded children without disabilities. And that's the standard in that case was argued at the U.S. Supreme Court that the parents were looking for. Okay, just to clarify on this, remember this thing about the Andrew F. case. The Raleigh decision that had been around in 1982, and that was the defining case with respect to educational benefit, dealt with a child that was fully integrated. So if the child was fully integrated or mainstreamed into the regular classroom, FAPE usually meant that the IEP is reasonably calculated to permit the kid to advance through the general curriculum. Now, what we had with Andrew F. was a child who was not in the general curriculum. So some of our students with autism, when they're partly in the general curriculum or they're in a self-contained type class, that Raleigh standard didn't really define how we look at what a FAPE is. And that was really what Andrew F. was compared to Raleigh. Raleigh was the case where a child was proceeding through the general curriculum, and Andrew F. was a child who was not proceeding through the general curriculum. That's why they said every child should have the chance to meet challenging objectives. Again, Andrew F. was meant to be more generally applicable, with the understanding that each student case is factually specific and unique. And as you all know, that is absolutely true. You can't have a bright line rule with respect to the appropriateness of IEPs. That's why there are so many levels here of review in Texas, whether we have the complaint process, you have the mediation process, you have ART facilitators, you have due process, and that can be appealed up through the various courts, because a lot of times there's misunderstandings as to what exactly is an appropriate IEP. And of course, that's what we're dealing with. That's what we try to look at as we review cases. What is appropriate? How did a hearing officer, how did a judge view something as to whether it was appropriate? Okay, let's look at the Supreme Court. So at the current term, we're here in March 2021. This is the 2021-2022 term, which begins on the first Monday in October. The big cases this year at the U.S. Supreme Court, and we'll see them come out probably in the springtime. So usually around May and June, that's when the Supreme Court really issues the big letter decisions. This year, the two big cases or the two big issues are Roe versus Wade. So abortion is big. That's the one that a lot of the country is looking to in terms of, well, it's the Supreme Court, how are they going to deal with Roe versus Wade and the cases that are pending there? And then gun rights is another issue that's a pretty hot topic this year. Overall, as it stands currently, the court tends to lean a little to the right based on the last few appointees. The last one, the newest judge, is Amy Coney Barrett, who's appointed during the Trump administration. She tends to lean a little more conservative. Of course, Justice Stephen Breyer, who tends to lean left, just announced his retirement from the court at the end of this session, at the end of the 2021-2022 session. He's been on the court for several decades, and the president has appointed or nominated at least Judge Jackson to fill his spot on the court. So we haven't gone through any of the vetting on that with respect to the Congress. The Senate has to approve the nominee to the Supreme Court, and those hearings haven't taken place yet since she was just nominated recently. But she tends to lean left, so it'll be a replacement for Stephen Breyer. But if she should be appointed, she's 51 years old, and of course, as we know at this point, constitutionally, the federal judges are appointed for life. So let's look at the term for this year. We have the rule of 4. So that's called granting of certiorari. So you wonder, sometimes you hear about cases that seem like they're going to be very influential. If you ever been involved in a case, even from the hearing officer standpoint, you think that case is critically important and new issues. It goes up through the court process. Is the Supreme Court going to take a look at it? And chances are they probably will not, because they get so many petitions to hear the cases. So the rule of 4 means that 4 of the 9 justices on the Supreme Court have to decide, yes, we're going to grant certiorari. In other words, we're going to look at this case. So there's only a few situations where the Supreme Court is required to hear a case. For example, when there are cases between the states, those are not discretionary, but just about everything else is discretionary. Which means that they can review it if they choose to review it. And the way they usually get there is when there's a conflict among the circuits. So if the Fifth Circuit, for example, has a conflict with on the same issue with another circuit, like the Ninth Circuit out in California on the West Coast, then the Supreme Court might take a look at it, because we got to resolve this circuit conflict. So that's how they come about. We don't have any special ed cases up there this year. We get a special ed case about every 4 or 5 years. And as I said, the last one that was important was the Andrew F. case, which kind of set that standard or renewed that standard that we look at to determine whether we have a fate. But as of currently, something could come up in the rest of the term. Currently, we don't have any SPED cases pending at the Supreme Court. From the education standpoint, we do have a few cases. There's one on affirmative action that applies at the college level, and that's dealing with race-based admissions to schools. That's been an ongoing one for decades. And the reason it keeps changing is because there's never a solid like 5-4, 6-3 decision where the law is real clear. They're always really convoluted. There's a lot of concurring opinions, and it keeps going back and forth. And the last time the court ruled on affirmative action, you had 2 other judges. Justice Ginsburg was still on, and she's passed away. Kennedy retired, and there's one other change that occurred. So they'll be taking a new look at it. For us in the K through 12 environment, it might have the general principles might have some application. For example, admissions to magnet schools. If you have a school district that has a magnet school that requires basically you have to apply for it and get in, might affect those decisions. So they're keeping an eye on it, and National School Board's keeping an eye on that. First Amendment became an issue. It was a Houston case that was decided a couple of weeks ago. Religious school choice, that seems to rear its head every couple of years. And probably the closest that is relevant for us in the special education context. There's a couple of cases dealing with Section 504 of the Rehabilitation Act. First of all, and neither one of them are school cases, but they apply to federal funding, so they would apply to school cases in the long term. The first one is whether 504 allows damages for emotional distress. It means, we'll talk about some when you go to courts under Section 504. If there is intentional discrimination, sometimes damages are allowed. The question is whether there are damages for emotional distress. The appellate courts have said no, but that's pending before the Supreme Court. And then disparate impact. Disparate impact is a legal theory that's been around for a long time. And it basically means that when you don't have an intentional act towards a person based on race, sex, disability, whatever it might be, but you have a policy or procedure that affects somebody in a protected class, for example, a student with a disability. There's no intent there to harm. There's no bad faith. There's nothing gross misconduct or anything like that, but you just have a policy that on its face impacts a student with a disability or based on a racial minority, whatever it might be. So one of the questions the Supreme Court is looking at this term is whether any of Section 504 allows that standard to be disparate impact as opposed to just intentional discrimination. Okay, another thing on our IDEA cases moving forward, we don't have a case on this yet because it's not quite in effect, but I wanted to mention it. It's the statute of limitations and IDEA cases moving forward here in the state of Texas. We had some changes to that, to the education code through the last legislative session. So it's something that's coming in September of 2022, and we need to be prepared for it now. But this will affect all cases, including autism cases before hearing officers. And the statute of limitations, that refers to the law that establishes the amount of time that a conflicting party has to commence litigation from the time of the alleged offense. So if today is March 1st of 2022, in most cases, if the event happened today, I would have until March 1st of 2024, the 2-year statute of limitations to file suit. Or if I'm looking backward, I can only go back to March 1st of 2020. If it is February of 2020, that would be outside of the 2-year statute of limitations if that's what we're dealing with, okay? And again, the whole purpose of statute of limitations is to ensure that lawsuits and litigation are dealt with promptly, okay? Because for a lot of reasons. We all, I'm getting up there, my memory fades. Trying to remember what I did a day, 2 days ago, a week ago, much less 2 years ago, that's kind of difficult. So as memories fade on all of this, our testimony, our recollection, our credibility becomes less reliable over time. So like I said, memory loss, you might have conflicting testimony inaccuracies in there. Over time, there's no way to go back and check on that. Also, witnesses become incapacitated for some reason, or God forbid they may pass away, but that's not uncommon on litigation that goes on for a long time. So again, it prevents long drawn out litigation. Now in the school context, the under IDEA, what it says under federal law is that a parent must request an impartial due process hearing, or if it's a circumstance where the school can do it, within 2 years of the date the party knew or should have known about the alleged action that forms the complaint. Or if the state has an explicit time limitation for requesting hearing in such time as state law allows. So basically we have IDEA says it's a 2-year statute of limitations, but they allow the 50 states to decide on their own, do you want a shorter one? So for years in Texas, we've had a 1-year statute of limitations. And again, the reason it's 1 year is because you want those, if there is a dispute with the kids program, and if we do have some issues that need to be fixed, you want that dealt with quickly, because the student has a chance of being more successful the faster we can do it, the more expeditiously we can do it. So what we had then, we have through the education code changes and through the last legislation, it was House Bill 1252. And basically what this said, it changed through the Texas Education Code 29.0164, it changed it to align with federal law. So basically, the commissioner or nobody can come in and say that the statute of limitations is going to be shorter than the 2-year statute of limitations that we have in federal law. Now, when this came out, it was opposed by basically all the state groups, educator groups, and school district groups. For a lot of reasons. One, they said, you know, the procedural safeguards were already there, they're in place. And then technically, if you're looking at 2 calendar years, that can stretch into 3 school years. And then, you know, schools are saying that's a long time to go back because, yeah, you're going to have staff changes. I mean, if you think about how quickly teachers may move around or administrators, they might go to other districts, they might change campuses, and then you have to, it gets more convoluted the farther you go back. And also they said, you know, there's already exceptions in federal laws that can take you beyond the 1-year statute of limitations. All those arguments were for naught. The legislation passed, and there we are. So starting in effective September 1, 2022, we're going to have a 2-year statute of limitations. And it'll be interesting to see how that plays out, because when you get close to that, you might have some of the advocates waiting until the new deadline before they file, because they're going to be able to go back farther than 1 year. They're going to be able to go back 2 years. So we'll be interesting to see if we get an influx of cases as of September 1 of 2022 that go back over the 2 years. So we'll wait and see on that. Okay, so just keep that in mind moving forward, that we have the 2-year statute of limitations going into effect in Texas, and it's going to align with the federal law. Let's go back through some of the cases here from 2021. I've got some cases at the 5th Circuit and a couple from the Texas hearing officers. Again, there wasn't a lot as far as the federal courts were concerned this year that covered Texas that specifically dealt with autism cases. There was a few in the hearing officer realm, but with that being said, these cases are important, whether, you know, because they deal with behavior, they deal with appropriateness of IEPs, BIPs. They're going to be relevant as we deal with students with autism. So usually when the 5th Circuit decides a case, particularly if it's a published case, they're going to have some applicability to really any special education case that we look at. So the first one I have up here, it's KS versus Riesel ISD, and this was issued on November 22nd of 2021. This was issued by the 5th Circuit. This is an interesting case. There were some substantive issues and some procedural issues that the court addressed. At the end of the day, the school won this case, and there's some important guidelines for us. So let's go through some of the facts on that. In this Riesel case, the parents requested an evaluation when the student was in 11th grade. Okay, so the student was already a junior high school. The student had some math struggles and had some outbursts of anger. And the kid had also had, really over his history, it had some disciplinary issues. So the parent requested the evaluation. I think it was in March 2016, maybe. The evaluation was conducted 8 weeks after the parent request. Okay, so within 8 weeks, the evaluation was conducted. And the school district found that the student was eligible for special education as learning disabled. So it's interesting that at the hearing officer level and at the court level, the parents weren't arguing that there was a delay in getting the evaluation and that delay was unreasonable. But of course, it became a child find issue, and they said that, you know, the school should have identified the student earlier, based on the kid's uneven academic performance and his disciplinary history. When the parent approached the school district about testing, they also presented the school with a private evaluation. Now that had been conducted by an outside evaluator when the child was in 3rd grade. And the child wasn't even in the Riesel ISD at the point that private evaluation was done. So we all know from the special ed standpoint, you can already see a problem there in the parents' argument that the kid is 11th grade, and evaluation was done in 3rd grade, and the first time they presented that evaluation was when they requested testing in the junior year. So that's a huge gap in there. You know, school districts can be held responsible for that. So they did the testing, and they found that the kid was learning disabled in math and I think in reading perhaps, which wasn't even a suspected category. So they did find that the child was eligible, but they didn't do psychological for ED to deal with the behavior issues, because they said really the disciplinary issues that we had with these kids were no different than what we had seen before. Okay, the parent also stated the IEP was inappropriate because the student was mostly educated in the general education program. The IEP and the kid's IEP, when after the evaluation was done and it was put into place, it required some of these accommodations that are done in the general education program, like changing pace of instruction, checking for understanding, reminders to stay on task. Okay, so that's what the parents were complaining about the appropriateness of the IEP, saying that was just, that was just something that could be accessed in the general education program. Therefore, it wasn't individualized to his needs. So what happens when the kid is still in high school, he turns 18, and then a couple weeks after his birthday, he engaged in an assault on school property. Of course, if we have an assault on school property, what does that mean? It means he's getting a free ride to the DAP, correct? As long as we have the MDR. So we do the MDR, but they did not invite the student to the MDR because they had a trespass order against the kid from coming on campus, so they didn't include him in the MDR process, although the parent was involved. They had the MDR, and the committee found that there was no link. Okay, then they had a subsequent MDR. So the first one was held about 8th day, and then in September, I think about a week later, they did a subsequent MDR, and they held where both the students and the parents were present. So that's where you can see they're alleging a procedural violation because the kid was 18, we didn't have him present at the MDR. And then when we did have him with then you're outside of the 10 days. So what did the Fifth Circuit do on this? So they ruled in favor, the court ruled in favor of the district on all issues. With respect to the evaluation, since the parent had not previously requested testing, and the district personnel didn't suspect a disability, they said that was a timely issue, okay? And then the prior private psychological report, which went back to the 3rd grade, was never presented to the school until the parent requested the evaluation. So you can see just from that time frame what you're looking at, and a rule for the school district on a child fine issue when there had been no previous request. And also, again, the school didn't suspect a disability. When you look back at the academic things, certainly the kid had some issues. For example, he had failed some algebra in one of the other classes, but he was able to pass the exams. He was the STAR testing. He was able to get by with all of his testing and pass all that. So in that regard, the school district didn't suspect a disability. Again, with the behaviors, they weren't consistent with traits of emotional disturbance. Again, basically the school indicated that as far as the behaviors were concerned, they weren't, although the kid had a pretty decent disciplinary history, that the behaviors weren't out of whack in that regard. Therefore, the school district won on that issue. So even though those behaviors were substantial, it wasn't necessarily out of the ordinary, and they didn't suspect them to do additional testing for emotional disturbance. The interesting quote here from the court, I've got in italics on there, regarding the IEP. The court stated, individualization does not mean that no two educational programs can be alike. It simply means that a student's program must account for his individual needs, and performing at grade level may well be an appropriate goal for a student like KS. So the fact that he was in general education with some accommodations was sufficient. Like the court said, just because two kids might have the same program doesn't mean it's not individualized for that specific program. So I think that's an important quote out of the Fifth Circuit's decision on that. And even bigger, really, you look at the level of concerns that we had with the MDR, the timing of it, not having KS there, even though he was 18, and then going back and having it outside the time frame. And then they apparently didn't even have all the information that they should have had, but the court said that that was not, the procedural violation did not result in a denial of FAPE. So when a procedural error, to have a denial of FAPE, it must be substantial and it must affect that child's ability to learn or for the school to implement the IEP. Because on this one, they said that by having the second one, the first art committee was not predetermined on the second IEP. In other words, when they went back in September and did the second MDR, they reviewed all the information again. The parent was there again, the student was there, and they said that didn't preclude participation because he was eventually allowed to participate, and the art committee the school folks hadn't made a predetermination after that first one. What's interesting on that, despite all of that, the kid did not participate in the second one. So we didn't offer anything according to the court's determination after a review of the record that he didn't participate in that second one. All right, so that's the Riesel ISD case out of the Fifth Circuit from November. Now we have one, BF versus Klein ISD, and this was from April of 2021. This is kind of a sad one, and this really just shows the importance of providing remedial measures, okay? So, we're all involved in cases where we did something wrong, and as opposed to burying our head in the sand, you go out and you fix it. It's really that simple. And I think this case really represents one of those situations, some sad allegations here, but I'll show you in a minute what the district did to fix things. So what we have here, BF is a student that receives special education services. He's got a lot of physical and cognitive issues going on. He's got communication issues, problems with walking and balance, and toileting issues. So the allegations that came forth. So remember, in a lot of these on these cases, the allegations, some of these are decided at the very early in the process at the federal court level. Okay, so sometimes when you read these decisions, you're thinking it's based on a full-blown trial that occurred and that the court had all of the evidence in front of it. But that's not always the case, because a lot of times they're deciding what's called summary judgment, where the court determines whether there are any issues that need to go forward for the court to hear, where you have a full evidentiary hearing. So when I say the parents allege, that's what was in their pleadings. They allege that this stuff occurred, and then the district responded with some of that. So what the parents alleged in this circumstance was that there were classroom videos, and I'm sure there were, that showed staff members intentionally causing physical injury or contact. The parents also alleged that the bus driver on this kid's route yelled and screamed at the student. The allegations further stated the student came home at least once a week with a soaked diaper, and that the school is not working on the toileting skills. And there was a lot of other various allegations that stated the student received scratches, bumps, and bruises over the years. So it was interesting. It's not really an IDEA case, although it's based on special education. At this point, the parents went to federal court seeking money, because you don't get monetary damages under IDEA, but you can get monetary damages for intentional discrimination under the Americans with Disabilities Act in Section 504. So that's how the parents filed the suit, under ADA in Section 504. So the lower court dismissed the case. So the lower court, what I mean is the district court dismissed the claims, and then it went up to the Fifth Circuit Court of Appeals, and the Fifth Circuit agreed. So they affirmed the lower court's dismissal of the claims. But it was interesting to note that the facts as set forth are tough, you know, and the court noted that the family's experiences were unquestionably heartbreaking, okay? But that doesn't necessarily rise to the level of liability, because the standard for district liability under the Americans with Disabilities Act and 504 is whether the district had acted with deliberate indifference. And what deliberate, you see it phrased different ways. Deliberate indifference means gross misconduct or bad faith, and it's a very high standard to me, okay? So even though those things occurred, the question is whether the school district would be held liable under 504 for monetary damages for the actions, if they occurred, by the staff members. And then the court said it didn't rise to that high standard of deliberate indifference for the following reasons. It said the district administrators promptly investigated and responded to the concerns. Importantly, the district terminated the teacher and the aide and notified Child Protective Services, which were required to do under the law, right? The bus driver was removed from the route. And so the district took these actions to fix the situation. And although the court did state that it was logically conceivable, is what it said, that additional staffing could have helped, it declined to speculate because we don't really know. They said these things have been prevented. You had another person on the bus, another aide in the room, you know, whatever it might be, could the additional staffing have helped? And it says conceivable, but they declined to speculate. So again, they dismissed the case, and this demonstrates the importance of going through remedial measures. Now let's take that. Let's start with district administrators have promptly investigated and responded. Let's say they didn't take those actions. Well, now you're getting a lot closer to 504 type liability, deliberate indifference. That's why we always say, regardless of the facts that you have, you know, some of these you're required by law, like to notify CPS, but you take the appropriate actions on the HR side, you investigate and you respond. And again, remember, we're even required to have the best investigation in the world, but you can't sit on those things. You have to investigate, respond to the parents' concerns, and then take these remedial actions. Because if they hadn't done that, I suspect the Fifth Circuit would have allowed, probably would have allowed this case to continue on, because now it becomes a fact situation as to whether that the district's actions were deliberate indifference. But they acted appropriately here. And even though the facts were tough, the school district is not liable. Now, as far as individuals are concerned, as it stands today under the ADA and 504, there is no individual lawsuits. Okay, another case out of the Fifth Circuit. It's DHH versus Kirbyville Consolidated ISD. This is from 2021. So DHH was a senior in high school, and she got good grades, had consistent attendance. Excuse me. In her 8th grade year, the parents had emailed the school to ask for an evaluation. Okay, so she said an evaluation under 504 and or an evaluation under special education, or do both. And so the district did both. Okay, so the Kirbyville CISD, they went ahead and they evaluated for special education, but they found that DHH was not eligible. So the parent filed for due process, and it wasn't really discussed as much, but the hearing officer found for the district on eligibility, but awarded reimbursement for the costs of the private evaluations. Okay, so the hearing officer found for the district on eligibility, but awarded reimbursement for the cost of the private evaluations. So the parent then filed in federal court, challenging that hearing officer's decision on eligibility and seeking accommodations under 504. Okay, federal district court ruled in favor of the district and the parents appealed. Now, what's interesting about this, if you see, like compared to the prior case, the Klein ISD case, the parent on the 504 side, first of all, challenging the hearing officer's decision on the SPED side, but was they're seeking accommodations. They were not seeking monetary damages under 504, but they wanted were accommodations under 504. So when we got up to the Fifth Circuit, the Fifth Circuit affirmed the dismissal of the parents' claims. Okay, so really the issue they affirmed with respect to the hearing officer's decision. The issue on the 504 part of that, on the disability discrimination, was whether the parent had alleged the proper standard. So in the last case, and then when I talked about the Supreme Court cases up there at the beginning, you talked about this disparate impact rather than intentional discrimination. So what the parents argued in this case is, since they were just seeking accommodations from the court and not seeking monetary damages, the issue should be disparate impact as opposed to intentional discrimination. In other words, did the procedures in place, the policies in place, even though they weren't intentional actions, did that cause a disparate impact, or did it cause harm to their child? And the Fifth Circuit didn't buy into that. They disagreed and said that, no, you still need to show intentional discrimination, which, as I said, is gross misjudgment or bad faith, in order to have a claim under 504 in those circumstances. But at the end of the day, what you look at, the district offered educational services. They conducted the evaluations, and those evaluations under 504 and under special ed demonstrated that she was the kid was making progress in school. So what we always go back to, educational need. Okay. So again, that disparate impact, or asking for the accommodations, is it's more of an equitable type remedy as opposed to monetary type damages. But as of now, that at the Fifth Circuit, they said, no, you still have to show intentional discrimination, but that could change with the U.S. Supreme Court. All right, so let's look at a couple of Texas hearing officers' decisions. First one is Student versus Schertz-Cibolo Universal City ISD. This is from April of 2021. This is one of Cynthia's cases. So we'll go through this. This case is at a district court right now. The parents have appealed up. The district won on all the issues, and this was an autism case. You know, it's an interesting one because the child hadn't been in the school district for a couple of years. So it kind of shows us, you know, how do you deal with these situations where the parents have taken him away? Of course, we still owe the responsibility of providing a FAPE if the kid is a resident of our district, but if he's not there, how do you go about gathering information and developing an appropriate program? So the parents alleged that the district denied FAPE, okay? And by denying FAPE, they sought reimbursement. So these are one of those types of cases that can get pretty expensive. They sought reimbursement for unilateral private placement at an autism day center, a residential placement that was out of state, a prospective residential placement, and then transportation costs for transporting the kid to all of these placements, all these private placements, and visiting the child out of state. So you can see how that can add up. So it was reimbursement for an autism day center, residential placement out of state, a prospective residential placement, and all the transportation costs that go with it. So like I said, the kid had been enrolled outside of the district for several years. So when the school was meeting to put together an IEP, it was limited, okay? So what do we do when it's limited? We try to seek that information. So if the kid is at a residential placement, we try to go and observe. We want to talk to the folks there. We seek any of their records. We seek their educational progress records. What are their behavior records? So you look for all that information, okay? The school tried that, and the record shows that they had demonstrated many efforts to get that information from the private placements, including attempting on-site visits. But they were always afforded minimal opportunities. So they were never given the chance to really get out there and analyze all this as they were trying to put together a program where the kid could come back to Schertz-Cibolo, okay? They also made significant efforts to involve the parents. And that didn't always come to fruition either. The parent attended most of the ARD meetings, but they didn't provide as much information as the district needed to put together a program. So based on the information available, this district developed the IEPs and developed BIPs on what they had. So the hearing officer determined that the school district provided FAPE with its proposed IEPs, okay? So on these unilateral placement cases, these reimbursement cases, if the hearing officer or court eventually finds that the district provided FAPE, then you don't really get to the question of reimbursement, because that's where it stops. If the district could provide FAPE, then they don't have to get into that second determination as to whether the private placement was appropriate. And the hearing officer in this one stated that the district did all that it could do in terms of designing an IEP that would provide the student with a program that is designed to provide education and related services so that the student would make progress. Okay, and I think that's the key in this one. They did all they could do in terms of designing the IEP. They didn't have all the information they wanted available, but they had enough where they thought this is what how we're going to do it. The district crafted IEPs based on available information and knowledge, and as such, they were reasonably calculated to provide an educational benefit. That's what the hearing officer said. Again, and this shows the importance on these types of cases, if the parent's not being cooperative, and the importance of going to these residential facilities or private facilities, so you can see how those programs compare to what you've got. And 9 times out of 10, you're going to be able to provide what they have available, particularly from the educational standpoint, which you have to show that those placements are educationally based. This public school district can usually do what's being accomplished at those other facilities. So the school continually sought information through our meetings, attempting to visit and confer with the residential facilities, but it just didn't happen. The district also offered parent training, and the parents declined any training. And they were looking at, just through that training process, providing assistance to them while the parents while the kid was still in the residential facilities, and trying to train just consistency across environments, you know, to address this kid's behaviors and trying to get him back into Schertz civil. Again, like I said, under the legal standards, there was no need to address the appropriateness of the private placements since the district provided FAPE. The parents also alleged a procedural violation. They basically said that the parents weren't equal participants in the process, which is, you see that a lot in these cases, these complaints, is that they're not allowed to be part of the process. But the parents had attended all of the ARDs for the kid except for one. And the one they didn't attend, the district tried to get him there. The parents didn't want to attend because they wanted to wait for until the hearing was over. So it's important to document those situations. It's apparent if we ask for information and the parent is not providing the information, if they want to wait for the hearing to take place or for a complaint to be resolved, whatever it is, you might want to document all those situations, because this is a great example of where that became important in the long run when they're alleging they weren't allowed to participate in the process. Okay, we've got one more. It's Student versus Huddle ISD. This came out in March of 2021. This case, there's this one component on autism and child find that I carved out. It's a much more complicated decision that deals with other issues. But for our purposes, I carved this out because it deals with autism. And what had happened on this one, the student's neurologist had referred the child to a BCBA for evaluation and treatment for mild autism. So the BCBA observed the student for somewhere from 6 to 8 hours outside of the school setting, so that wasn't in the school setting, and conducted various tests like CARS tests. So the outside BCBA, he determined that the student exhibited behaviors that were consistent with autism and not necessarily attributable to the student's ADHD diagnosis. So what he did, he said, based on those behaviors, he recommended that the student be formally evaluated for autism. So the ARD reviewed the report and offered to evaluate for autism and provided a consent form to the parents. But what happened, so again, the district, that recommendation was brought forward by the outside BCBA. The ARD reviewed the report and made the determination that we'll go ahead and do the evaluation, but we need written consent. The ARD adjourned with the intent to reconvene, but it never happened, okay? So the ARD never came back. The parent didn't return the consent form, and she withdrew the student before the meeting can be reconvened. So on that issue in the case, the child find issue, the hearing officer again found for the school district determined that it did not violate the requirements because they had no reason to suspect autism or a related educational imbalance was already addressed. Okay, and the second component of that, the hearing officer determined that the district was ready and willing to conduct further evaluation upon receipt of the parents' written consent that they never got. So there's two bases here. First of all, they said the school district, there was no reason to suspect autism. And then secondly, that they were ready and willing and able, we always hear about those letters, to conduct further evaluation, but we needed the written consent, of course, which required under the law. And they never got that because the parent withdrew the student and never brought him back. But if we just go back a couple years before, there had been a prior FIE. And going back to that first component about no reason to suspect autism, in the prior FIE, the district had found that the student's social pragmatic skills had fallen within normal limits. And they looked at the student's strengths, and if you look at these things, that doesn't look like autism at all. The strengths included eye contact, social greetings and manners, topic initiation, conversational turn-taking, positive affirmation of others, and use of facial expressions appropriately. So none of that really would raise the level of a school district suspecting the need to evaluate for autism. And finally, the hearing officer said that, based on the evidence, the student's behavior and sensory needs were typical of the student with ADHD, and therefore there was no reason to suspect autism. So that's the last slide I have with respect to our case evaluation. Like I said, we're seeing some more hearing officer decisions now. We'll keep tabs on this, and we always, as we do our conferences, we always like to do these legal updates. I took the most important facts and determinations out of these cases. Some of these, as you know, might be 50 or 60 pages, but we look to whoever's going to provide us guidance moving forward. So I thank you for paying attention. I thank you for participating in our overall conference. We have some really good topics. I hope you enjoyed it. And I look forward to seeing you in person soon. Everybody have a good day.